next case to come before the court is State of Ohio versus Deprise. Are all parties present?
Sure.
Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I'll be keeping track of time. The arguments are being recorded, so please keep your voices up and stay behind the podium. Please introduce yourselves as you begin. You should not use the names of minors or children or victims during your argument. You can refer to those folks by initials or generic terms like the child. The judges have read your briefs and we're ready to proceed when you are. And I would just ask appellant, would you like to reserve time?
Yes, Your Honor, I'd like to reserve 3 minutes.
Very well, then we are ready when you are.
May it please the court, Kevin DiMartino on behalf of the state of Ohio, the appellant in this case. We are asking that this court reverse the trial court decision dismissing the indictment in this case. With regard to the underlying facts, the defendant in this case was indicted in 2017 for aggravated vehicular assault, failure to stop after an accident, and driving under suspension. The defendant pled guilty to all the charges, and a sentencing hearing was scheduled out at the time with the understanding that the parties were free to argue with regard to sentencing. About 4 years later, the victim passed away, and the defendant was indicted for aggravated vehicular homicide. The defendant moved to dismiss the indictment, arguing that the prosecution was barred because the state had not expressly reserved the right to further prosecution if the victim died. There was a hearing. The state argued that this case does not fall within the line of cases starting with State versus Carpenter because there was not a negotiated plea in this case. And at this time, the state reiterates that same argument that this case does not fall within the line of cases including State versus Carpenter, State versus Dye, and State versus Azim because there was no promises. Therefore, there were no promises that could be broken by the state proceeding with an indictment with regard to the homicide after the victim in this case passed.
But doesn't the record indicate otherwise? The plea form says plea agreement is stated as follows. That wasn't crossed off. It says free to argue. And then there was an objection to a no contest plea where the prosecutor says this is in contradiction to our plea agreement. So we have 2 places where there's an indication on the record that there is a plea agreement.
So the state would argue that that indication is a false indicator because when you look at the transcript from the hearing on the motion to dismiss, the trial court prosecutor testified that the written guilty form was a form that had that title, written plea of guilty, and that it was required in all cases by the judge in that courtroom, and that it was required regardless of whether there was a negotiated plea or a defendant simply wished to exercise his right to a plea.
So if the state wanted to reiterate that there was no plea agreement, they could have crossed that out and wrote there's no plea agreement. But instead it says plea agreement is free to argue.
It was a pre-printed form. I don't have, there's nothing in the record to indicate that they were ever adjusted in that way. Instead, what the testimony was is that that form was required by the judge, regardless of whether it was a negotiated plea or not. So it doesn't say negotiated plea agreement, it just says written plea of guilty. With regard to there was clearly no amendment to any of the charges, nothing was dropped. And then the sentence does say free to argue. And when you are in a trial court courtroom, and you're talking about an agreement, most of the time when someone is free to argue, that's an indication that there is no agreement. Otherwise, there would be a discussion at least as to what charges are being dismissed or amended, or specifications that are being dismissed, and or an agreed recommendation with regard to sentence, and that is not there. The courtroom prosecutor also testified that...
But let's go to the no contest plea,
Yes,
because there is a benefit to the defendant being able to plead no contest. And
Correct.
One of the benefits is there's no civil liability, or there's civil liability is not conceded.
Absolutely.
Another benefit is that you preserve some legal arguments that you didn't have with the guilty plea. So when you object to a no contest plea, there is some benefit to the state of the defendant pleading guilty.
I agree.
So there is don't you think that, is that evidence of plea agreement as well?
No, because in this case, what the prosecutor said was that is in violation of the plea agreement, and what he was referring to was that form. So there was no agreement to allow the defendant to enter a not guilty plea. If there had been an agreement for a no contest plea, that would show there was an agreement between the state and the defendant. But what it showed, the record instead, was that the defendant, on his own, because he didn't want to go to trial for whatever reason, decided to plead to the indictment and plead guilty, and that's what was on the form. So the prosecutor wasn't saying, this isn't what we agreed to. He's saying, I am not agreeing to a no contest plea, for the reasons you talked about, the benefits to the defendant, and the fact that the victim in this case, who had horrible injuries, including a severed spine, did not wish for there to be any negotiations. And the trial prosecutor also indicated in that hearing it was not a negotiated plea. He had been clear he was not negotiating a plea, and he was set and ready for trial, which was upcoming. So while those things are in the record, and at first blush they might sound like some indication of a plea agreement, a negotiated
And
plea
counsel, what about the, I don't remember exactly the words, but you probably will. What about the comment about not putting the victim through another day of this? Wasn't that a benefit of?
That is always a benefit for the victim, but for the state, but there's no, the negotiation under contract law, right? There has to be something that is inducing a promise, something for the defendant. There's nothing in here. So even if the state did get some benefit, and certainly the victim who didn't want to go through, let's say, a trial, though that victim, by all indications, was ready and willing to go to trial. She gave a very long and passionate victim impact statement. So I don't know if we can even say that was a benefit. She might have wanted her day in court. That's not really in the record. So I don't know if I would even agree to that. But either way, there's no evidence that that was a promise or some kind of benefit to the defendant. So there's no evidence that he said, you know what, I'm going to enter a plea of guilty to all the charges of the indictment because of this. And there's no indication that the state said, yeah, we'll allow you to plead to the indictment, which is your right, because we won't want our victim to go through that. I mean, sometimes victims, the benefit is they do get to come into court and testify about what happened. So with regard to that, I don't think that that's an indication for a negotiated plea. So there was nothing in this case that, as far as charges dismissed or amended, there's no agreement as to sentencing. It's clear it was free to argue. In fact, when you look at the sentencing transcript, the prosecutor asked for the max, which was 6 years. The defense asked for something less. The court gave 5.5 years, so did not give what either side was asking for, which is further indication that there was not a negotiated plea, especially with regard to sentence. And with regard to the court's finding that the death was foreseeable, the trial court prosecutor testified that he did not believe at the time of the plea that the injuries were life-threatening. So there were very serious injuries, but at that time she was in court, she was in a wheelchair. She had spent some time, a few months in the hospital, but that does not mean it was foreseeable that she would pass. But more importantly, I think for purposes of this case is the issue of whether or not there was a negotiated plea. And under the cases, when you look at State versus Carpenter, they talk about contract law and the existence of a negotiated plea. In State versus Dye, they look at the importance of making sure that the defendant doesn't have a broken promise that was made by the state. If that promise is what induced the person to enter the plea, there's no promise in this case. There's no indication that anything said by the state is what induced the defendant to enter the plea to all the charges in the indictment. And then when you look at State versus Azim, which is the most recent Supreme Court case on when a state has to reserve the right to further prosecute if there's a negotiated plea, the court clearly goes back through all the contract law and looks at the scope of the agreement and what the understanding was of the parties. And when you look at the transcript on the hearing for the motion to dismiss, the understanding of the state was that the defendant was exercising his right to enter a guilty plea to all the charges in the indictment with no promise or inducement with regard to any amendment to the charges or an agreement as to sentence.
Isn't there some other prejudice to the defendant as well? For example, if this charge would be allowed to be brought and he was sentenced on this charge, but he was also sentenced earlier to lesser included offenses or things that would merge, would then the court never be able to make that merger analysis? And
they don't apply because the offense hadn't occurred yet. That's why there's no double jeopardy argument either, because since there was no death, the
but the sentencing would matter.
Right.
If the defendant sets on both matters.
And that would be an entirely separate argument. This is just an issue of, under contract law, was there a negotiated plea? And if there was a negotiated plea, that would bar further prosecution if we did not reserve the right to go ahead and prosecute if the victim died. So we're just arguing that there was no negotiated plea. Without a negotiation, regardless of some, colloquial terms that are used in court, or, when a court requires a form and they call it a written plea of guilty form, and they want that form in every case where there is going to be a plea, whether it's negotiated or not, that doesn't transcend into a negotiated plea. So the state would argue that based on the case law and the facts of this case, based on the testimony of the trial court prosecutor as well as the transcript from the plea hearing and the sentencing transcript, there is no evidence of an actual negotiated plea. Therefore, the case law, starting with Carpenter and most recently in State versus Azim, does not apply, and the state should be able to proceed with the homicide charges that are based on the death of the victim 4 years after the accident.
Counsel, before you have a seat, I have a question for you. So the hearing record, the transcript of that, as well as the plea hearing and the sentencing hearing are all in front of the court?
Yes, they were.
It's in the record?
They are.
Okay. Did the court, pursuant to Rule 11, ask the defendant at the time of receiving the plea, has anybody promised you anything in return?
I don't recall that, but I do recall the prosecutor saying that it was his understanding that this time the defendant was going to enter a plea of guilty to all the charges, and there were no promises, inducements, or threats made to him. So I know that part was in it.
Thank you.
Thank you, Your Honors.
Thank you. You'll have your full 3 minutes for rebuttal.
Thank you.
Good morning. Well, we disagree. This is my first time making an oral argument where I actually won in the lower court, so it's a different experience. It's also the first time I've won a dismissal in front of Allison McCarty, also a different experience for me. And when I prepared for this, I reread all the documents in front of the court, and I reread Judge McCarty's ruling on the motion to dismiss indictment. And it is my entire argument, and it's laid out perfectly, and she does a better job than I could have. I want to point to page 4. Prosecutor, the state would object, Your Honor. Court, well, this is being thrown at me today. Prosecutor, Your Honor, it's a violation of the plea agreement. When we look at who's supposed to understand what the violation is, right? In other words, who's supposed to understand, is there a plea agreement or is there not? Well, we have from the position of the government, we have the position of the defendant, and then we have objective third party. Those are 3 possible options. Well, let's start with subjective understanding of my client. He's standing there with his lawyer, he's entered a plea, he signed a document called plea of guilty, he tried to give himself some benefit to avoid civil liability. He was prevented from doing so based on a plea agreement. The judge viewed that in the moment, and this form we're talking about that she makes people sign, as somebody who's practicing that court, that's just not accurate. You don't have to sign a plea agreement, you can modify them, you can change them, you can do whatever you
Counsel, how do we know that?
I agree, Your Honor. I mean, that's not in front of the court. I'm just telling you, as an officer of this court and that court.
Yeah, I understand that, but we can't consider it. So
Okay.
I'm trying to figure out what we can consider. And so the plea agreement, is that in the record?
The plea agreement is in the record, yes, Your
Okay,
Honor.
and is it called a written plea agreement?
Yes, Your Honor, written plea of guilty.
Okay,
Yeah.
well, obviously.
And there's parties that sign on the final page, and the question you asked, Mr. Martino, regarding promises or inducements, that's one of that's the language right in the signature saying there is no, when he signed, there is guaranteeing there is no. So that's handled in writing as well.
Okay, and it also should have been done at Rule 11 as well.
That's correct, yes, Your Honor.
And so if he said no, why is not that the end of the inquiry?
Why isn't that the end of what inquiry?
Well, if he says there's no promises that have been made for me to induce me to make this plea of guilty, doesn't that negate there being a plea negotiation?
Well, no, because what we're actually talking about, when that question is asked, at least in my experience, when the question is asked, that's about, has someone promised or threatened you? Is somebody giving you money to do this? Is there some kind of, if you do this, you're going to get probation, we guarantee it, even though it says prison right here? That's a question about, is somebody having undue influence upon the defendant? Not are the parties here agreeing to the document in front of us?
Well, that can be part of it, and it should be part of it. But also, every sentencing or every plea I've ever taken and ever reviewed, there's they're supposed to say to the prosecutor, is this a negotiated plea? If it's not, if it is, then they want to know what the negotiation for, what was promised. And then you ask the defendant, as the trial judge, have any other promises been made to you that have not been relayed to the court at this time? So the prosecutor said there were no promises.
Okay?
Is that right?
The prosecutor also said this isn't a plea agreement, even though he objected saying it's a violation of the plea agreement.
Well, maybe it was because the plea agreement said guilty plea. That's just a written plea agreement.
Maybe. We don't know. What I can tell you is subjectively, from my client's understanding as to what was going on, as a defendant who's not an attorney standing there in that moment, he has a reasonable belief, and a reasonably foreseeable belief, this resolves the matters in front of this court. And the government, Cletus Pulliam, who's standing there, who is an attorney, who understands the possibility and reality of reserving the right to prosecute later based on these same facts, chose not to make that reservation.
Well, counsel, isn't that a different issue, though, than whether or not there's actually a plea agreement? Because you can argue that you entered into plea agreements and that did resolve everything, and you had a reasonable belief that it did resolve everything. And then the case law looks at whether that was reasonable or not. Usually it happens when there are misdemeanor cases that they plead to in muni court, and then there's a subsequent felony charge on the same set of facts.
So on the plain language of the document that was actually signed, I see plea agreement is stated as follows. Is there anything in that document, in the plain language, that says it's not a plea agreement?
No. No, there is not. And I guess I would submit to you that unlike some of the other cases in Judge McCarty's ruling with the case law lineage of, I've got them highlighted in here, Carpenter, Tadai, you got Jackson, Muhammad, some of those involve people that were in comas, right? In this case, the victim was in court, in a wheelchair, had a 30-minute on-camera discussion with the defendant, at which point she forgave him, accepted the plea, said it was justice, and then 4.5 years later expired at 77 years old. So the idea that somehow these injuries were not foreseeable is just not a reality when the victim's present and details to everybody who will listen, including my client, as to the severity of her injury.
Well, that also could go just to the fact whether she actually died as a result.
That's a whole separate issue,
I
obviously.
agree, that's what my whole point is.
Yes, if on the facts of this argument, if we had not won this, we would not have appealed this. We would have then moved on to the second prong, which is, can they prove causation? But obviously, we're not there. From a position of if you then pull back to 10,000 feet, and a person sitting in the gallery watching this proceeding, they would believe this resolves the matters in front of the court. Because of all the things that were said, because of the objection based on the no contest, because he's basically conceding civil liability. And Mr. Pulliam admits that there was a civil case pending. So that had profound impacts on active litigation. So it wasn't just a throwaway, it was a substantial benefit to the victim. And she was happy with that result in court.
I guess I'm still just having a little bit of problem trying to understand why that wasn't put on the record then. The prosecution was going to, let me finish. The prosecution was going to allow a no contest plea and is going to stay silent on sentencing.
You're saying why wasn't that put in the record?
Well, you seem to be arguing that he gave up his right to have a no contest plea.
He did.
Okay, and that was something that the prosecution bargained for, basically.
Well, all I can do is read what actually happened. When he tried to assert his right to give a legal plea to the full indictment, the prosecutor objected, quote, "It's a violation of the plea agreement." I don't know what else he's supposed to believe.
What did he say at the hearing that meant?
Mr. Pulliam?
No, the prosecutor.
Yeah, Mr. Pulliam, the prosecutor.
Oh, is that?
Yes, I'm sorry. He was a little unclear. Honestly, I found his testimony at the hearing, as I was present and the one cross-examining him, I did not find that to be a believable rendition of what those words mean. Because if that doesn't mean it's a plea agreement, then why'd you say plea agreement? Unlike Mr. Moore, Deprise Moore, who is not sophisticated, who is not an attorney, this is a member of our bar. And when you say things that have legal consequence, they have legal consequence.
But wasn't the defendant represented by an attorney?
Of course.
Well, why do you keep saying that what he understood? Attorney was there to represent his rights, correct?
Right, but because of the case law, we're on the subjective understanding of the individual.
I
That's why I'm,
understand that, but
that's why I mentioned
that
that.
to me is a different case law analysis. But go ahead.
So further, a violation of the plea agreement, and then there is a sidebar in there as well from the original transcript, and then discussions are had, and then Mr. Grevin, who represented Mr. Moore at the time, had a conversation with Mr. Moore, and he said, I'll continue with my guilty plea. So this was an analysis that happened in real time, but he gave up a substantial benefit that benefited the state and the victims. I mean, I don't know what other definition of a plea agreement exists. And so then, and again, all I can go off of is what I have seen, and what I see here is a 6-year maximum sentence where he got a 5.5-year sentence. That sentence, if compared to other cases of similar import where there is a fatality, is a severe, if not greater than normal sentence on a death case, let alone just an accident injury case. But, and that's why, again, everybody present would have believed this matter was over. And that's all I have. Thank you.
Thank you, counsel.
Thank you. With regard to the prosecutor's use of the term plea agreement, the prosecutor did not say negotiated plea agreement. The prosecutor was asked about whether he said plea agreement. He acknowledged that he said that. He was very clear he did not mean a negotiated plea. When the prosecutor, the current prosecutor asked the former prosecutor, were you referring to that written plea of guilty? I believe his answer was probably. When you read it in totality, it's clear that what the prosecutor was referring to is that written plea agreement. With regard to what is in the record, a hearing on motion to dismiss, the prosecutor was asked about that written plea agreement, and the prosecutor said, when I was a prosecutor in Judge Bro's court, it was customary that every plea we have a plea form. That plea form would be signed by the prosecutor and the defense attorney. It's my recollection the defendant would also sign, and this is for each and every plea. The defense attorney asked, so in a case where you have not negotiated to reduce or dismiss any of those charges, in a case where there's no agreed sentence, you would still have to do a plea form? The answer, that's correct. Question, so it's not possible at that time in front of Judge Bro to enter a plea as a defendant unless you did a plea form? Answer, that's my understanding. Through all the cases that I handled, there was always a plea form involved. So to be clear, it is in the record that the testimony was that Judge Bro required that form, negotiated plea or not. So whether the defense attorney has had a different experience and it's not in the record, is not what the court can consider. The court can only consider what is in the record. Further, the form does not say it's a negotiated plea form. It just says that it is a plea form.
Counsel, one of the things that the appellee brought up that, you know, is a reasonable point maybe, and that is, what about the fact that, you know, we're not negotiating, but even just pleading guilty, even if we don't even say there's a negotiated plea. With that type of charge, and with the person being alive and at the hearing, and nobody indicating that there's, to the defendant even, that there's a possibility of death, why would it not have been reasonable for that defendant to consider that he was pleading to universally get rid of every possible charge that could be brought against him from this case?
Well, for one thing, there was no agreement to anything other than he's pleading guilty. So I understand, you know, should we find that because a person is represented by counsel and has had the advice of counsel, we should explain what this plea is limited to. The prosecutor also didn't foresee that this person would die. I believe the defendant, when he spoke at the sentencing, he was kind of surprised when he saw the victim in the wheelchair, hadn't realized the severity of her injuries, but did not seem to think in any way, shape, or form this victim would die. I guess I find it, I'm getting to your answer, but the fact that this woman was in a wheelchair and had had very severe injuries, to say that it's, you know, just ludicrous to not see that she would die from those injuries, I do not agree. Plenty of people have had the, you know, horrible misfortune of being involved in a very serious accident and live a long life in a wheelchair, paralyzed, and don't die.
Counsel, I'd ask you to
Wrap up.
I
So-
just have one quick question.
Yes. Mhm.
If we look at this form, it'll be in record,
Yes.
and is it on its face modifiable? Like, for example, if there's different levels of PRC, do you X a box?
You can write in there.
So there's
Right.
places places where it can be modified.
Sure.
For whatever the circumstance allows.
In the body of it, when it says what they're pleading to, you could write that.
You can
But the
write-
caption on the top is already captioned. I mean, you'd be crossing through a caption document, which, and when I would enter a plea on the record, I would say we reached a negotiated plea pursuant to criminal rule 11, when I had a negotiated plea. If not, I would just advise the court, it's my understanding at this time the defendant is gonna enter a plea of guilty when it was not a negotiated plea. The case law does not have a test to say, well, what would the defendant have thought by terms of the agreement? What the analysis has been from Carpenter to Azim is whether there are elements of a contract and what was the understanding of the parties. And it would be through his attorney, not through what he thought standing there. That is the point of having counsel. So with that, I will wrap up and I would ask this court to reverse the trial court's decision dismissing the indictment.
Thank you. Thank you both for your presentations. The court will take the matter under advisement and issue a decision in due course. The courts will mail a copy of the decision to you on the day that it is released, and the opinions will also be posted on the Ohio Supreme Court website. Thank you both again.
Thank you, Your Honor.